Hello everyone and welcome to the Supreme Court Observer. I'm Sai Spandana
And I'm Gauri Kashyap.
and you're watching SEO's list of the top 10 judgments of 2023. As you can imagine, curating a list of 10 key judgments of the Apex Court is not an easy task. This is true for 2023 especially, where the court disposed of 52,220 cases. It was also the year of the most number of Constitution Bench decisions in recent history. The cases touched upon weighty issues like civil rights, political rights, personal liberty, freedom of speech, distribution of governance powers, and the nature of federalism. Several decisions were viewed as the barometer for the health of democracy and the independence of the judiciary.
In some cases, the court acted quickly and decisively, such as when it issued a stay in the defamation matter in Rahul Gandhi's case, enabling him to return to parliament. The court also granted bail to activist Teesta Setalvad in an evidence forgery case, while calling the order of the Gujarat High Court perverse. It also granted long-awaited bail relief to the activists arrested in the Bhima Koregaon case. But on certain other matters, it dragged its feet. Activist Umar Khalid is still in jail without trial, and there is no sign of the Pegasus spyware case being taken up for hearing. So perhaps our list is bound to be subjective, but we've tried to cover cases that have shifted the needle on some aspect of public law. Either the law was changed or its interpretation. Make sure to comment below and let us know what you think should have made the list. Now for SEO's list of top 10 judgments of 2023.
On 11 December, a constitution bench led by Chief Justice D.Y. Chandrachud upheld the central government's revocation of the special status of the erstwhile state of Jammu and Kashmir. The court agreed with the union that Article 370 was a temporary provision as it was placed under Part 21 of the Constitution. It also upheld the presidential orders that abrogated the provision, ruling that it was not a malafide exercise of power. However, part of the presidential order that amended Article 367 was held to be constitutionally invalid. The court refused to comment on the validity of the reorganization of the state on the ground that the Solicitor General had submitted that statehood would be restored to Jammu and Kashmir in due time. You'll remember our extensive coverage of the case with live tweets, detailed daily reports, videos, commentaries, matrices, summaries, and much more. We hope you've checked them out.
On 17th October, a constitution bench led by CJI D.Y. Chandrachud rejected a batch of petitions that sought the equal right to marry for sexual minorities. The five-judge bench unanimously held that there is no fundamental right to marry under the Constitution of India. They held that marriage flowed from social customs and that the court cannot recognize it as a right. Further, it could not place an obligation on lawmakers to codify an institution that the law itself did not create. Four judges held that the Special Marriage Act of 1954 cannot be held unconstitutional for excluding non-heterosexual couples from its fold. Justice S.K. Kaul was the sole dissenter, holding that the SMA's initial purpose of interfaith marriage does not justify the exclusion of queer persons from its ambit. Three of the five judges were of the view that queer persons do not have the right to enter into a civil union. They found that it is not within the court's power to recognize the right to compel the parliament to make a relevant law. CJI Chandrachud and Justice Kaul, in the minority, held that there was a right, in fact, to civil unions. The bench was unanimous in its view that transgender persons in heterosexual relationships have the right to marry under the existing legal frameworks. This is another case that SEO has tracked in detail. This includes our hearing reports, our judgment matrices, our argument matrices, and a lot more. Make sure to head to the website to read our coverage and expert commentary on this case.
You'll remember the Shiv Sena crisis in Maharashtra in 2022. A faction of the Shiv Sena, led by current Chief Minister Eknath Shinde, had rebelled against the then Chief Minister Uddhav Thackeray-led party. Upon disqualification notices being issued through the Deputy Speaker, the rebel MLAs moved a no-confidence motion against the Deputy Speaker and the Thackeray government. Before a floor test ordered by the governor was conducted, however, Thackeray resigned and Shinde became the Chief Minister. Thackeray challenged the governor's actions and the Shinde faction's rebellion at the Supreme Court. On May 11 this year, the court finally delivered its decision in the case. A five-judge constitution bench held that the Maharashtra governor's decision to order the floor test to gauge the support that Thackeray had was illegal. The reason was that the governor had no objective material to believe that Thackeray had lost the confidence of the House. The larger question of whether a speaker can decide disqualification petitions when a petition for his own disqualification lies pending was referred to a 7-judge bench. The conflict, however, has not come to an end yet, because despite the court's judgment directing the speaker to decide the disqualification petitions within a reasonable period of time, they are yet to be processed.
On 11th May, the same day that the Shiv Sena judgment was delivered, a constitution bench led by CJI Chandrachud held that the government of the national capital of Delhi, and not the lieutenant governor, controls the capital's civil servants and day-to-day administration. The bench unanimously held that the Delhi Legislative Assembly has the power to make laws extending to all subjects in the state list of the 7th schedule of the Constitution, except public order, police, and land. This means that the legislative and executive power over services such as the Indian Administrative Services or Joint Cadre Services shall lie with the Delhi government and officers, though not recruited by it, and would still serve under the state government. The judgment upheld the principles of federalism in stating that Article 239AA must be interpreted to further the principle of representative democracy. A week after the judgment, on May 19th, the President promulgated an ordinance which put the powers over services squarely back with the Union government. An amendment act replacing the ordinance was passed by Parliament in August. The National Capital Territory of Delhi Amendment Act 2023 restored the Delhi Legislative Assembly's power to make laws with respect to services. The provision creating the National Capital Service Authority was retained.
On 21st March, a 5-judge constitution bench led by Justice K.M. Joseph modified the process of appointing members to the Election Commission of India. The bench emphasized the importance of an independent election commission and created a committee consisting of the Chief Justice of India, the Prime Minister, and the leader of the opposition in the Lok Sabha. Though the duty to frame the law for the appointment of members to the Election Commission fell within the legislature's domain, the court took note of the inordinate delays and parliamentary inaction while clarifying that its directions would hold till Parliament makes its law. Less than 4 months later, however, on August 10th, the Union government introduced the Chief Election Commissioner and Other Election Commissioners Appointment Bill of 2023. The bill proposes a selection committee which excludes the Chief Justice of India. Instead, the committee will comprise of a Union Cabinet member of the Prime Minister's choosing. The Lok Sabha approved the bill in December this year.
In November 2021, the President passed 2 ordinances. This allowed the Union to grant extension to the tenures of the directors of the Central Bureau of Investigation and the Enforcement Directorate. Petitioners argued that such extensions would interfere with the independence of investigative agencies from the executive. They argued that the Union could then incentivize the heads of these agencies to take union-friendly actions. In July 2023, the court unanimously upheld the validity of these ordinances, stating that the independence of the agencies would not be breached as there were sufficient safeguards that insulated them from the pressures of the executive.
On 18th May, a constitution bench led by Justice K.M. Joseph upheld the practice of bull-taming sports such as Jallikattu and permitted the state's amendments to the Prevention of Cruelty to Animals Act of 1960. The bench relied on a Tamil Nadu government's argument that Jallikattu was a key part of the state's culture which had been practiced for centuries. However, the court refused to venture into the question of whether a cultural right existed in this case, stating that it was an exercise that cannot be undertaken by the judiciary. The bench also stated that the fundamental rights of animals do not have any precedent in Indian law.
On 24th January, a constitution bench streamlined the guidelines for the withdrawal of treatment of terminally ill patients. The court relaxed the procedure to get an advanced medical directive, which is a document containing end-of-life instructions to be used when a patient is no longer able to communicate their wishes. The alteration of the guidelines was undertaken in response to the Supreme Court's judgment in Common Cause v. Union of India, which held that the right to die with dignity is a fundamental right under Article 21. The court tweaked a lot of stringent requirements. This included reducing the minimum years of experience required for the certifying doctor and the requirement of a chief medical officer on the board. They also made way for expedited decision making by the certifying boards, preferably within 48 hours of the case being referred to it.
On 1st May, a 5-judge constitution bench led by Justice S.K. Kaul held that in exercise of the court's inherent powers under Article 142, it can dissolve a marriage that has been irretrievably broken down. The bench held that if the court is fully convinced and satisfied that the marriage is totally unworkable, emotionally dead, and beyond salvation, it can exercise its powers to do complete justice to the parties involved. This decision, the court said, must be based on factors such as the duration of the period when the parties last cohabited, the nature of the allegations, the attempts at settlements of dispute, other court orders, and the duration of the couple's separation. With this decision, the court departed from the procedures laid down in family law frameworks which do not recognize irretrievable breakdown of marriage as a ground for divorce.
2 judgments were delivered on this topic this year. On 25th April, a 5-judge constitution bench in a 3-2 majority held that an unstamped or insufficiently stamped arbitration agreement was void and unenforceable. The decision, however, met with immediate criticism for creating practical difficulties in resolving urgent matters. In September, a 5-judge bench led by the Chief Justice decided to reconsider NN Global and referred the case to a 7-judge bench. In December, the 7-judge bench upheld the validity of an unstamped arbitration agreement. The bench reasoned that not stamping was a curable defect and would not render the whole agreement void. This decision stands out for one more reason. It's the first 7-judge bench judgment in 5 years.
And with that, we wrap up our list of our top 10 judgments of the year. We at SEO have tracked all of these cases extensively. Head over to our cases page for our detailed coverage on each and every one of them. As part of SEO's 2023 review, we've written about the most important hearings of the year, the number of pending cases, the number of cases filed and disposed of at the Supreme Court this year. Head over to seobserver.in for a snapshot of 2023 at the Supreme Court.
Make sure to comment below and let us know what cases and institutional developments you thought were important and what you would add to the list. We'd also like to take this moment to thank you all, our viewers, for watching and engaging with our content this year. Stay tuned for more news on the Supreme Court at seobserver.in. Thank you for watching.